Okay, that's enough.
Yeah, we got good guests tonight. I ain't wasting a lot of time.
Yeah. Welcome to Hit or Miss. I'm Night Strike, as always, and that was the musical stylings of Smeggy. Go ahead and say hi, Smeggy.
Oh, hi, Smeggy.
All right. I want to introduce my panelists tonight. I've got more than a couple tonight. Figure that one out. Sean, what's going on?
It's a great time to be an American and to be a Floridian. We've got a lot of good bills pending in the legislature this year, a couple of bad ones, and we're looking forward to fighting against the bad ones and working on the good ones, and hopefully can move the ball forward.
All right. I want to talk about that. We got a latecomer, Jimmy. Say hi, Jimmy.
Yo.
All right. Then we got Nathan. Nathan, that's your cue.
You're going in and out there. Just making some ulsters. Going to give you all my opinions.
All right, and then we got Heavy B. What's going on, Heavy B?
What up? Recovering from a hangover after my birthday.
All right.
Happy belated birthday.
Thanks.
We've got Travis.
Hey, what's going on, guys? This is Travis. You can check me out over on gunchannels.com on the Ordinary Average Guy Gun Channel.
And last but not least, we have Sean's lawyer, Eric.
Oh.
Say hi, Eric.
And like a lawyer, he's still learning to use a computer.
And his computer is not working.
He's just choosing not to speak at this time. He's using his right to remain silent.
Y'all do realize this is the man that will keep you from being sent to prison and put on death.
He's about 70 miles away from me, and I can hear him cussing right now because he doesn't have his microphone plugged in, probably.
Or he's got the mute button on.
No, because I saw the thing unmute.
And he's underneath his desk right now trying to plug the mic in. And every time we say something, he cusses and hits his head into the top of the desk. Son of a bitch!
Just for these things, we sent him a blue snowball. We made sure he had a good microphone. And he's going, damn it, I put that in a box when I was moving my desk.
Well, okay then.
Eric, if you need IT help, I do IT on the side. So, if you need some help, let me know.
Well, if you need to keep your gun or get rid of your wife, call Eric.
All right. Well, when he gets
get rid of your wife, make sure she doesn't get your gun.
Ooh, that's good.
There is a lot of that. And it's probably a good topic for conversation. What's been going on with some of the complications that come out of divorce when it comes to your right to bear arms?
Generally, it's probably a good idea to not let your wife know that you have guns in the first place.
Oh, come on now. That's not right.
That's how you get out of that right there.
Have you never been married?
I was going to say, I got lucky. I kept mine. He took the pink ones. It wasn't much of a loss.
I haven't been married. Does it show?
If you've ever been married, you know that that's just not possible.
I haven't. So,
And marriage is built on trust, Night Strike.
Well, shit, I'll never get married then.
Well, when your wife
Hold on, I
says
found
you
a
don't have a
loophole.
choice,
Hold on. I found a loophole. I buy and sell guns, not as much as Yankee does, but I do it a lot. I'm not even sure what I have in my stock or inventory. It's also random and crazy. So,
I thought marriage was based on prenups.
Well, maybe it should be.
I believe have the guy that can talk about that.
Maybe he can talk about it.
I believe it was 5 or 6 years.
All right, guys. Should we just start without him and just wait for him to,
That's what I say. At least let's get an overview of what's going on, and then
He'll
hopefully get the
sort
shit
himself
done.
out in a minute.
One at a time, guys, so I can actually hear you.
Y'all have me now.
Uh-oh, now he's there. Quick, stop talking about him.
Did you pull the snowball out of a box?
Actually, I had to disconnect the snowball and go to the cam mic because the snowball is not working for some reason.
That could be because of a daughter.
Daughter, operator error, who knows?
Yeah, I think the problem occurs between the chair and the keyboard on this one.
Watch it, or he might get you for libel.
No, because I have to say something untrue for libel to count.
Exactly. Truth is always a defense, and Sean's criticism of my technological capabilities is entirely accurate.
And it wasn't in print, so it's clearly slander. Come on, get it right.
Well, sorry, we're just mere common folk. We don't know the real legal jargon all the time.
We don't know legal.
You'll have to forgive us.
Yeah, that's why we pay you guys.
All right, so Sean, what's going on with open carry in Florida? You know, what's going on with you? And you're the founder and one of the chairmen of Florida Carry, are you not? Sean, you're muted.
Yeah, there he goes, yakking away with it on mute. Yes, I am the founder, chairman, and executive director of Florida Carry. There are two executive directors, myself and Rich Nascak are at the head of the organization. But yes, I'm the chairman. And we have a lot going on in the legislature. Right now in Florida, we are just starting to file bills. Our legislators, after the election, have just taken their seats. We are just getting the committee assignments. We are just getting the new rules for lobbying. And we are just starting to get the new bills. That said, very rapidly, we've had a number of bills filed that are going to impact the right to bear arms, including open carry, campus carry, and your right to be innocent until proven guilty in a case of self-defense. We have some bad bills. We have one that will say that if someone breaks into your house and steals your gun, you're liable for it. So if someone breaks into their house, you go to jail if they steal your gun.
That is completely ridiculous to me.
Oh, it's an absolutely ridiculous bill. What the Democrat legislator who filed it is trying to do is, well, just make you more in trouble if your gun gets taken by a child and does something wrong with it, including if they break into your house and steal your gun. What they are trying to do is mandate that all guns be locked up, which is what the Heller case said, the DC versus Heller, and the U.S. Supreme Court said that you cannot force people to lock up their guns and make them inoperable for immediate self-defense. People need to be able to be in their home and have immediate access to a gun if someone kicks down their door. The Supreme Court understood that. Unfortunately, this legislator wants to pass unconstitutional legislation.
So how is that even a question then? How could that even be a question then? If it's already been proven unconstitutional, how could he even bring it to light? How could it even be a question?
Because sometimes people don't understand what is constitutional and what is not, and don't like what is unconstitutional and what is not.
But again, it's already been determined that it's unconstitutional, so it shouldn't even be brought. It should be laughed out.
It won't be laughed out.
It should even be just outright rejected because it's already been proven unconstitutional. It should not even be anything.
It should be.
It's going to lead to automatic.
Has a right to file a bill, and this particular legislator filed an unconstitutional bill and is trying to put a constitutional spin on it. And this is why we fight so much in the courts. And unfortunately, we have a lot of lower courts that will allow for such unconstitutional regulations. And this is why you see so many of these cases going to the courts of appeals and even to the Supreme Court to get corrected.
Okay, so say this bill gets brought up and passed. It's unconstitutional. It goes to litigation. Is this something you say, look, U.S. Supreme Court already said this can't be done? Does that just knock it down right there, or do you think it would progress?
We make the argument, and the lower court judge may or may not say, "Yep, you're right. It's unconstitutional," and strike the bill down. More often than not, lower court judges rubber stamp enactments of the legislature, and we have to go to the Court of Appeals. And then we may or may not get a good ruling, or they may split the hair and say, oh, well, we found a way where this isn't exactly like what the Supreme Court said. So we're going to draw a distinction, and we're going to let this pass, in which case we go to either the state or the U.S. Supreme Court and get them to rule again. And this is why this election was so important, that we get the right judges who are constitutionalists, who are originalists, who are textualists, appointed to the Supreme Court, so that when we go to the Supreme Court with ridiculous cases like this that say that try and regulate something that the Heller Court already said that you can't, when we wind up back there again, that we have judges appointed like Justice Kennedy from Florida Supreme Court, who's on the list of judges that that President-elect Trump wants to appoint, that we get people like that who are going to say, no, we already said in Heller you can't do this, and we meant it.
So then when
now,
another state the wrong judge
appointed, we have the opinions like we got from Justice Breyer, which said that, well, guns are bad and we should do everything we can to limit them.
So once you get the two cases saying the same thing and another state does it, you can be like, now you're double wrong, which it will still have to probably go all the way back up to the Supreme Court.
Which means, no, when you've got a couple of cases that say the same thing, that's when the lower courts really start taking notice and going, yeah, we know we're going to get reversed if we do this. We don't like it. Well, we think it's horrible. We're bound by the Supreme Court, and therefore we rule this way. So the more cases we get that uphold the right to bear arms, the better we do at the lower levels, until finally we get to the type of protection that we have for the First Amendment. Where lower courts will uphold the First Amendment for the most part. But that's only because for the past 50 years, they've been being beaten over the head with the fact that the First Amendment is really a fundamental right. We have to do the same thing for the Second Amendment. Beat the courts over the head that the Second Amendment is really a fundamental right, just like the First Amendment. Because remember, the First Amendment wasn't even incorporated until what, Eric, what was it, 1920 something?
20s, 30s, sometime in that time frame.
Yeah. The First Amendment, has not really been alive for all that long either.
So I have a question for you, Sean, to keep up. Last year, or this year technically, when open carry was going on, you had that one state senator in Florida, Florida state senator, was it Portilla? He basically, bucked himself for blocking the open carry bill. Mm-hmm. And apparently he didn't get reelected. How about that?
Yeah, well, yeah, and there's a lot to that. You've got a In Florida, you have to go north to get to the south, which means that in the Miami-Dade area, we have a very metropolitan area, a very high population density, which is generally Democrat leaning.
I'm surprised Orlando isn't Democrat too.
It is. We have a Democrat mayor in Orlando. We have a Democrat sheriff, a Democrat police chief,
Democrat state
a Democrat state attorney. Which a state attorney in Florida is like a district attorney in most states. So we have some very liberal bastions of the state.
Y'all might want to know that Miss Corey, the recently defeated state attorney here in Northeast Florida, who prosecuted Mr. Zimmerman, she lost re-election campaign in the primary. She has found herself a new job. She has been hired by one of the sheriffs to be his general counsel in one of our outlying suburbs of Jacksonville.
Right. So Jacksonville being
also
being in North Florida means that you're back into the South. That is more of a Republican leaning area. However, and we might get into this, we might not. Just because you're a Republican doesn't mean that you're pro-gun. Just because you're a Democrat doesn't mean that you're anti-gun. We have some very pro-gun Democrats. We have some very anti-gun Republicans in the Florida legislature.
Which doesn't make sense.
It makes perfect sense when you think about it from the point or from the view of a libertarian. And I don't mean the anti-military, defense of the U.S. outside of our borders libertarian. I mean the true libertarian who believes in individual liberties. There are Republicans who believe in individual liberties trumping the state, and there are Democrats that believe in individual liberties trumping the state. The dividing line is really over what is the state's role, which is as it should be. Unfortunately, the Democrat Party in recent years has become, honestly, more fascist, more statist than Democrats used to be.
Right. So, we're kind of getting, sidetracked on that, but you were telling us what's going on with the law. So, I mean, for the layman, lay out some of these other laws that, you said aren't too great or are good.
All right. So the open carry bill, as it was filed, does a couple of things. It allows for the open carry of a handgun. It doesn't allow open carry of long guns, just handguns. But it says that you can openly carry a handgun. It goes a bit farther, though. It says that while you can openly carry a handgun, you can also, and if you can see what I'm scrolling through here, it says that you can also carry a firearm if you have a concealed carry license into a meeting of the governing body. You can't carry to courthouse, except that the courthouse is now, say you get called for jury duty, you can show up there while you carried your gun there and check in your gun, which is a good thing. It also says that you can carry your firearm into a K through 12. Well, at least in elementary or high school. Okay. If you have a concealed carry license.
Can I ask you a question about this bill real quick?
Yeah.
Hey, what does it do for out-of-state people? Does it recognize, does it allow, if I'm a concealed carrier and I have reciprocity with Florida, would I be allowed to open carry in Florida?
Yeah, if you have reciprocity with Florida, if you have an Ohio license or something, and you come to visit, you will be governed by the same rules as a Floridian with a Florida concealed carry license. We have another law that says that if you can do it with a Florida concealed carry license, you can do it with any license that we recognize.
All right, cool.
So you'll also be able to carry in the airport, but not the sterile area, not the area past the security checkpoint.
Well, obviously.
So they've included a lot within this bill beyond just open carry. They included airport carry. They included campus carry, which the sponsor of this bill is also sponsoring a campus carry bill. There is another bill that deals with airport carry that has been filed, and this bill deals with that as well. So this isn't the language that's in this bill isn't the language that we consulted on. The legislator that files it is a great pro-gun guy, and he's a former infantry officer, and he's an attorney. And he has put into this bill basically an all-encompassing all the things that we wanted to fix in the past couple of years about the concealed carry license all into one bill, turning it into an open and concealed carry license, and eliminating some of the prohibited places. So absolutely, we're going to be supporting the bill. We'll see what form it makes it out of committee in.
So as it is right now, though, you would still need to have a permit in order to open carry?
Yes, and you would still need a permit to open carry. There is no bill in Florida that will allow for any form of constitutional carry.
Well, not even constitutional carry, just like in Michigan, anyone can open carry, and then if you want to conceal it, you need to have a permit.
All right, so there's this giant misnomer out there over what is constitutional carry. Constitutional carry means that you have a means to carry that is constitutionally protected, be it open or concealed. Now, as we just learned from the Ninth Circuit, there's really only one method that has always been constitutionally protected, and that is openly carry. If you're a believer in the living, breathing Constitution that gets changed at the whim of whoever's in charge this month, then there's an argument to be made that constitutional carry means that you have a constitutional right to open carry or a constitutional right to concealed carry as determined by your legislature. I don't personally subscribe to that model. But it is unquestionable that the laws in this country and the right to bear arms have always allowed for open carry without a license. Unfortunately, none of the bills that are filed right now comport to that constitutional right. They extend the current law to make it a better situation, but they don't go all the way to protecting the Constitution.
That's one of the things that has always kind of surprised me about Florida, because you guys do seem to be pretty good on the gun rights side. You know, it's like your concealed carries was one of the, like the shall issue stuff, that was one of the first ones, and all the other states kind of copied it and all that stuff. And I was very shocked to find you didn't have open carry.
Yeah, there were a number of smaller states that had concealed carry before Florida. But Florida was the first big state to enact a right to carry, or not even a right to carry, to enact a privilege to carry. But we're the first one that said that we're going to license carrying a gun concealed, just like we licensed getting a driver's license. Except that, well, felons can get driver's licenses, felons can't get concealed carry licenses. But we're going to give you that privilege. And made it a shall issue. So, yes, there's a privilege, and if you're qualified, we will give you that license, period. Still doesn't make it a right, but it made it so that if you're one of the qualified people, then you can get it.
Now, with concealed carry in Florida, is it shall issue or is it may issue?
It's shall issue, but again, don't confuse shall issue with the right.
You're still asking for permission.
I mean, I'll give you a great example. There is this doctrine within the law, and Eric, jump in here if I screw this up, that says that you cannot pass an ex post facto law. Remember your old civics classes in high school? You can't take someone away. You can't take a right away from someone that you've already given them. You can't, after they've committed a crime, then make it, or after they've done something, then make it illegal afterward. So ex post facto is really one of those giant test between what is a right and what is a privilege. Because if something's just a privilege, not a right, you can take it away afterward by changing policies. So Florida said that you could have a concealed carry license if you meet all these requirements. And then a bunch of people got concealed carry licenses. And then they had a few people that they said, oh, wait, we forgot to say you can have a concealed carry license if you meet all these requirements and these additional requirements, which they found a few people that didn't meet those additional requirements. So they said, oh, yeah, we're invalidating your concealed carry licenses because we changed the law. They sued. They said, well, wait, you can't take away our right to bear arms ex post facto. After we've already given it to us, you can't just take it away. And the court said, no, you don't have this right to bear arms. Your bearing of arms is only a privilege. So we're taking away your license.
I'm pretty sure the Second Amendment says otherwise.
But remember, no one respected the Second Amendment until 2010. The Second Amendment's only been alive for 6 years. So
2008, Sean.
I think Heavy
Incorporation lost 2010.
You mean like living in California where they just strip us of our rights at will?
Yeah, I think from your point of view, you still don't have the Second Amendment. So
right,
your mileage may vary.
So
yeah, it goes back to, it's a privilege out here in California, and they just keep revoking those privileges.
So we came to the defense of a man named Dale Norman. He was arrested and convicted for openly carrying a handgun. And we went to the court and said, well, wait a minute. Okay, so this other case said that the concealed carry license is only a privilege and can be upset by ex post facto laws. Heller said that the right to bear arms is a right. So if you can't carry concealed as a right, you must be able to carry open as a right. And the other court said that, oh, whoa, wait a minute. Nope, the other court was wrong that took those licenses away from those people because they hadn't heard about the Second Amendment and its actual incorporation to the states. So therefore, we're going to say that the other court was wrong and we're right, and that you have a right to a concealed carry license, but you don't have a right to carry openly.
It seems really ass backwards.
And so we're in front of the Florida Supreme Court right now, and we're waiting for them to rule.
And how's that look like it's going to go?
Eric, I'm going to give you that one.
Well, the one of the issues that the court has to address before it really gets to the ultimate answer is what level of scrutiny are they going to use? There's different levels of scrutiny applied to different types of cases, but generally the level of scrutiny used answers the question for you. Generally, if the courts use strict scrutiny for a particular issue, then the individual is going to beat the government. If they use a lower standard of scrutiny, generally the government's going to be successful in upholding whatever law it passed. Well, the problem here in this case is one of the liberal justices just a few years ago said that anything listed in Florida's equivalent of the Bill of Rights, which is the Florida Declaration of Rights, anything in the Florida Declaration of Rights must be used, strict scrutiny must be used to deal with any law infringing upon those rights. Now, in that case, she was talking about a little juvenile delinquent who happened to have been out after campus curfew.
And she said this saying that no matter what other jurisdictions do, no matter what the federal courts do, no matter what other states do, in Florida, strict scrutiny is the law of the land. And
she actually went so far as to take to task one of the conservative justices on the court at the time who did not want to use strict scrutiny, quoted him, called him out, and reminded him that he had been quoted in another case as saying that intellectual honesty required the court to stick with this strict scrutiny in any fundamental right case. And so I made a point of reminding her of her quoting the conservative justice and her insistence on intellectual integrity and intellectual honesty. And one of the conservative justices was sitting there laughing his butt off as this all went down. So,
well, that's a good thing then, right?
Well, the problem is we have about a 2-2-3 split on the Florida Supreme Court. 2 conservatives, 2 moderates, 3 liberals. And more often than not, those moderates have been splitting to the liberal side in many cases.
Okay, well, even I'll say something off air later, but you know, you guys may have to start playing dirty. That's all I'm going to say.
I went about as dirty as it could possibly, as any lawyer would dare go in front of the Supreme Court and calling out a justice.
I'll tell you, if you have ever desired to watch a state Supreme Court case and a lawyer smack the hell out of the state or even some justices on that Supreme Court, you should watch the Norman case. And my man Eric Friday over here putting his thing down.
Are you saying that we need to make a YouTube remix, one of them gangster mixes, where he says some snarky thing and then we put on the hat and the glasses and some
the hat and, there are a couple of particular points I can think of right now where the hat and glasses were justified.
And I'll binge watch the whole season of that. Bring it up.
All right.
All right, there you go, YouTube people. You have a job.
Season 1, baby.
Find that.
Season 1.
It's only about 30 minutes long, so it's really not even that long.
Doesn't matter.
But I got to tell you that the best part of it was when I had never seen this before. The Deputy Attorney General representing the state made the mistake of asking the judge if something was his opinion, and the justice reminded her that his job, that he was the one that was there to ask questions. She was there to answer them, not ask them. He didn't answer questions.
Yeah, it sounds like my mom.
Oh, he straight up
Seriously, who wants to be in a court like that, man? Seriously.
Straight up mom.
Wow.
It was a who the hell do you think you are?
Woo. I'm sorry I missed that.
It's on the
YouTubes.
Yep.
And how would we find it on the YouTubes?
You find him a link, Sean?
Yeah, let me see if I can find it here in a second.
So I can try and search it. I just don't know what I'm looking for. Right?
All right, now I have a question in regards to scrutiny levels.
All right, go ahead.
If strict scrutiny is supposed to be like the highest level, the end all, the be all, law of the land type scrutiny, Why isn't everything being brought up in front of the state Supreme Court all under strict scrutiny? Wouldn't it make sense that this is the highest level, so you should be using the strictest
because
scrutiny?
statists don't like it. It means that they have to justify the things that they've done.
Yeah, but see, it doesn't matter what they like. That's the job they took.
Oh, you keep forgetting that judges are quite often also politicians.
Let me answer the question. So this is getting back to basic constitutional law concepts from law school. It started with
Now, hang on. Before you say this, I have to tell them what happens to lawyers in law school.
all right, go ahead.
Law school has one purpose, its primary purpose, and that is to beat the common sense that has been instilled into every one of us by our parents out of potential lawyers. So a lot of things that you will see in the law defy common sense because lawyers have been taught to reject it.
It also defies law too in some cases.
So anyway, the U.S. Supreme Court over the years has developed several different tests. These are strict scrutiny, intermediate scrutiny, and rational basis. And the idea behind these are the more fundamental in nature the right is, the higher the government's burden is going to be before they can regulate that right. So to give a few examples, in the area of free speech, and free speech is actually where this is generally taught the best. If the government's going to pass content-based, so you can't say anything ugly about judges. You can say nice things about judges, but not ugly things about judges. So if the government's going to pass a content-based restriction, we're going to make the government meet a strict scrutiny standard. That is, they have to be able to come into court and say, Judge, the legislature passed a law banning people from saying ugly things about judges because it was inciting people to violence, and this is the most narrow way we could tailor this law to not affect people who were just saying ugly things but weren't trying to incite violence. Obviously, that's generally going to fail, and the law is going to be struck down. Now, when the government's ban on speech is content neutral, we don't care whether you're saying nice things about judges, ugly things about judges. You can say whatever you want to, but you're not going to say it in the hallway of the courthouse while court is in session because that's disruptive. So now we're not regulating the speech based on the content of the speech. We're regulating the time, place, and manner. So we'll let you hold a sign quietly outside the courtroom, but we're not going to let you walk into the courtroom with that sign and distract the jury. Or we'll let you talk in the hallway, but we're not going to let you yell and chant in the hallway because that's disruptive to the proceedings. So that kind of restriction where it's content neutral and has reasonable time, place, and manner restrictions, that's going to be analyzed under a rational basis test. That being, does the government have a reasonable reason for passing this law and enforcing this law? And as long as it's a reasonable law, we're going to let them get away with it because they're not doing it to restrict the freedom of speech in total. They're just saying you can't do freedom of speech right here where you're going to be disruptive to other people.
Awesome.
I'm following on that. I still think that, well, again, I'm not a lawyer. It just makes sense to me. And again, thank you, Sean, for the explanation. Take common sense out of the equation. It cannot be applied. So I get what you're saying now.
Have we gone through every law yet, or are we still halfway through?
Well, that's the two main ones. There's a middle ground called intermediate scrutiny. And that's been further broken down into two parts, but the general idea of intermediate scrutiny, and this is important because in Heller and McDonald, the Supreme Court said, we're not even going to talk about levels of scrutiny for the Second Amendment because, for one thing, Scalia and Thomas don't like the whole level of scrutiny thing to begin with. So we're not going to talk about levels of scrutiny. We're just going to say, even under rational basis, this law would not pass muster. So it's gone. And that's a very odd thing for a law not to at least pass rational basis. Most laws can pass rational basis. So most of the federal circuit appellate courts have gone with intermediate scrutiny in
right. Well, actually, Eric, they didn't say it didn't even pass rational basis. What they said was it must meet some heightened level of scrutiny, which means something above rational basis.
They said it wouldn't meet any standard of scrutiny. That includes rational basis.
It wouldn't meet any standard of scrutiny, but any law implicating the right to bear arms must meet a heightened level of scrutiny. That means something, and which is interpreted to mean something more than just rational basis.
So here's the important thing about intermediate scrutiny, though. Intermediate scrutiny has been further divided. Depending on, and again, the judges a lot of times are picking what level.
Especially after Heller, it got more divided.
Most of the judges are picking levels of scrutiny, knowing the result they want to achieve, because the level of scrutiny by itself generally dictates the end result. But the other issue with intermediate scrutiny is it's been divided into those that are more fundamental right intermediate scrutiny and less fundamental right intermediate scrutiny. And the big difference here is, in a strict scrutiny case, generally the legislature has to have explained itself in a strict scrutiny case when passing the law to justify why they passed the law in the first place. In rational basis cases, the government, the attorney general, whoever, can come in and make up an excuse, even if it's directly contrary to everything every legislator said when the law was being passed. They can come in and make something up. On the higher end of intermediate scrutiny, they can come up with a new justification that hasn't been offered before, but it at least has to be consistent with legislative language, and they can't come up with it for the first time at the appellate level. On the lower end of intermediate scrutiny, they can change their version of why the law was passed as the case progresses through the appellate courts to try and make the judges they're currently in front of happier.
And so it's kind of like negotiating a deal kind of thing.
And
like, we want to pass this, but we know this will make you happy, so we'll add this in and then we'll take this out.
Yep.
Right. And the interesting thing about this, say you bring in the legislature, the legislator that sponsored the bill. They will say that, well, your intent when you pass this bill doesn't necessarily represent the intent of the entire legislature when they passed your bill. So even though you wrote it with this intent, that still doesn't represent necessarily the intent of the entire legislature. Again, remove common sense.
Yeah, I don't understand the mental gymnastics of basically saying, all right, I know it's wrong if I do strict scrutiny, but I can pretend like it's right if I only do kind of intermediate-ish. Like, how can you in your brain think that and then start fighting to get the type of like review that you want? It just doesn't make sense to me. If you know it's wrong, if you looked at it critically, then it should just be wrong. Like, how can you say, but if I pretend to ignore half of it, then it's okay?
That's called expecting integrity from our judicial system.
Yeah,
which
common sense.
You know, the more time I've spent with dealing with it, the more jaded I've become. I mean, the blinders have come off, and it's been soulfully wrecking.
All right. Well, with all this legal jargon allowing you to go this way, that way, or whatever, using different levels of scrutiny, why don't they just write laws in plain English place where everyone, including the layman, especially the layman, can understand the law being written.
Because then lawyers are out of a job.
That would put lawyers out of business.
No, because you're still going to need people
No,
to
no.
stand up and fight those laws for you.
No, don't be mistaken. The writing it in plain language opens it up to way too much interpretation. You have to be very specific when writing laws.
That would
so
be plain,
there aren't
wouldn't it?
loopholes later.
Wouldn't that be plain language, though? I mean, it's like
the problem
you are
is
not allowed to drink and drive. Boom. That's simple, right? You have to
unless-
wear a helmet.
what if
Simple.
there's a volcano going off behind you? Then can you drink and drive?
Well, then
Because
that falls
you would
under
die?
extenuating. Doesn't that at
But
that point
you
become
didn't write
extenuating
language for
circumstance?
that.
Wait, hold on.
All
Hold on. You said don't drink and drive, right?
Yeah.
Okay. So what's the legal limit written into the law? You got to add that, right?
And this is where I think the courts get into some of these areas, or
Where's
at
your
least
breathalyzer?
they
Where's
get
your
into the gray area.
observation?
To be specific on it, then, because I was just bringing up examples, just like plain worded examples. Like, okay,
Oh no, but that's a great
you
example.
cannot have, if you are operating a motor vehicle, you cannot have a blood alcohol content of blah. If so, you are in violation of the law. Plainly written, no legal jargon. I mean, it's very little legal jargon, but even the meanest of the lay person can understand it. Why aren't laws written that way?
They
That's
are,
the-
but
that's the
then
question I'm
there
asking.
are things like exceptions, the exception of necessity. There was a volcano going off after me, so even though I was over the legal limit, I was going to die if I didn't drive out of that place. In that case, you're not supposed to be culpable for just driving. Now, if you had caused an accident during that drive, then you are culpable.
Okay. Sean, can we get back some of those laws that have been introduced in Florida, or are we done with all those?
Right. So the other really important one that I talked about a little bit earlier was the issue of, are you innocent until proven guilty? And we have a bill filed that says that you're innocent until proven guilty when you claim self-defense. Currently under Florida law, and there was a case that Eric argued before the Florida Supreme Court, saying that we have immunity from prosecution when you act in self-defense. And that's what the law clearly says. If you act in self-defense, you are immune from arrest, you are immune from prosecution, you are immune from civil liability. And what the courts have done with that law that says that you're immune from all these things is said that, oh, well, you're only immune if you can prove that it was self-defense during your self-defense immunity hearing.
Well,
Which
that's
meant
that's
that
like the
you
hearing that
are
takes place
guilty
before-
until you prove yourself innocent.
Right, but is that something like that takes place like first, like before a criminal trial? And if you have a positive defense in that, like you do prove yourself innocent, then they don't charge you. But if not, then it goes on to the criminal one, and then that's when you're
well,
innocent until proven guilty.
They've already charged you, and then you say, okay, I want to say that I have this immunity. In which case you still have to bring a case. You still have to say, look, here's the facts of the case, and I've made a prima facie case of self-defense. I have made a case that is, on its surface, it looks like this really was self-defense. Fine. You've made that case. It really kind of looks like this was self-defense. Now prove it. Which gets very hard when you're the only witness. because the burden's against you, not for you. When you're the only witness, you're screwed because the burden is against you. When it gets to the criminal trial, and now you spent tens of thousands of dollars more on lawyers and experts and everything else, then the burden shifts back, and it's, well, it was self-defense, and you bring that prima facie case again, and you say this was self-defense, and then the burden's on your side, maybe, and that doesn't always work. Eric, you argued the case. Spell it out.
I'm sorry, I just got back on stand your ground issue.
Yeah, Bretherick.
Okay. So,
you know what? In fact, tell them about Dale Bretherick or Mr. Bretherick. Eric Bretherick.
Jared was 22, 23 years old, something like that at the time. He's riding with his parents, who are both disabled Vietnam era vets, and his 14 or 15-year-old sister. He's in the back passenger seat of Dad's pickup truck. They're down here visiting, going to Disney. And a gentleman named Dunning was driving so crazy, one of the state's own witnesses admitted he waited at a green light to let Mr. Dunning go ahead because of how Mr. Dunning was driving. Well, Mr. Dunning nearly ran Mr. Dad Bretherick off the road, and so Dad hit the horn. Dunning then got in the middle of 3 lanes, is a 3-lane highway going each way, busy part of Orlando, and he pulls into the middle lane in front of Dad, slams his brakes so that Dad comes to stop about a car length behind him. Traffic's flowing on both sides, backed up behind him. Dad can go nowhere. Dad needs a walker to get around. Mom uses a cane. Mr. Dunning gets out of his vehicle, and at this point, I'll let you know, Mr. Dunning was driving a Cadillac Escalade SUV with, or I'm sorry, I can't remember if it was pickup or SUV, but with $4,000 in cash that he was on his way to go pay his overdue child support, but he doesn't have a job.
Well, at least he was trying to play child support.
Well, he had $4,000 in cash and no job. You do the math.
Well, if you believe the excuse afterward that that's what he was doing.
With his
Mr. Dunning got out of his vehicle and walked back towards the Bretherick vehicle. Dad Bretherick reaches in the glove box, gets the gun out, holds it up in the windshield. Mr. Dunning goes back to his car. Instead of leaving, he backs up closer to the Brethericks. Now, he later testified that he was, he couldn't leave because he was blocked in. All the witnesses said he was not, including the state's witnesses. The judge found him uncredible as to him being blocked in, but he backed up closer to the Brethericks. At this point, Jared's the only able-bodied adult. All 3 adults in the vehicle have concealed carry licenses. Jared's the only able-bodied adult. Dad hands him the gun, and he's in the back passenger seat where he has no vision of what's going on or what happens if Dunning gets out of his vehicle. So Jared Bretherick gets out of the vehicle and moves to the driver's side of the vehicles. And at this point, there's a dispute as to whether Mr. Bretherick approached the window of Mr. Dunning or whether he stayed back by his vehicle the whole time. The interesting part of this is the state's 2 witnesses and Mr. Dunning say that Mr. Bretherick came up to the door of Dunning's vehicle and pointed the gun through the window. Both of the state's witnesses put Mr. Bretherick at the driver's side door of Dunning's vehicle. Dunning claimed that Bretherick was at the passenger side door of his vehicle. My supposition, my belief is what the witnesses saw was Dunning getting in or out of his vehicle because they only saw one person outside of the driver's side door of Dunning's vehicle, and Dunning got confused about which side he was supposed to put Mr. Bretherick on and put him on the passenger side, because I'm pretty sure I might have some.
Eric, I think you're into extraneous detail over which side he was on.
Sorry. But I always thought it was interesting because I would remember what side of my vehicle the gunman came up to.
Yeah, that seems an interesting fact to be like, I'm not sure.
So anyway, by the time the cops get there, Mr. Bretherick is standing. Mom and daughter escape, run across heavily flowing traffic and hide in a ditch, roadside ditch. Dad stays in the car, opens his door, and son is behind Dad's door, gun in hand, pointing it towards the Dunning vehicle when the cops show up. Mr. Dunning also has a prior road rage conviction for yanking a guy out and beating the hell out of him. While this case was pending, Mr. Dunning is caught on video going into a business associate's office and beating him without provocation. And Mr. Dunning has a history of beating up his pregnant girlfriend / fiance, whatever.
So he's a bad guy.
He's a bad guy.
We get that part. Okay.
Multiple felony issues. And so the judge said, well, it's Mr. Bretherick's obligation to prove by preponderance of the evidence that he was acting in self-defense, rather than the state's obligation to prove that he was not acting in self-defense.
So, and he didn't even shoot him or anything, though, right? Is that what I'm gathering?
No shots were fired, nothing.
The cop showed up with him holding a gun pointed at bad guy.
Yeah, bad guy's blocking him in.
I didn't shoot that a-hole.
Yeah, bad guy's blocking him in, won't let him leave, has sent his mother and sister running into a ditch. His father is disabled.
And he's protecting his dad.
And he's protecting his family. And he has the burden of proof. And so charges against him are moving forward.
Well, it's been pled out now.
Eric, you hadn't told me that.
That was old news. You just forgot.
Okay, he pled out to lesser crime, or
he pled out to I forget it. He pled to a misdemeanor, which generally that would be brandishing. He pled to a misdemeanor, 12 months probation, withhold of adjudication.
And is that just
unfortunately
because
sometimes
it looked like he was going to lose?
Which means he lost his gun rights.
For 12 months, for a year.
For a year, yes.
Just for a year. He had a year, so he didn't have to go through a trial and spend money.
And here's the thing. That case was going to fall under 1020 life. He was going to have to do 10 years minimum mandatory.
Three.
Yeah, that's right.
So,
the 3 years.
How is he not? How could that not be proven as self-defense? Again, I know common sense. Not an issue here, but
he didn't want to risk it. He didn't want to roll the dice on some douchebag jurors from Florida voting against him.
And I will say this on a live chat where it could come against me in a court of law one day. Given the same situation, given the fear that he had, as I understand it, he was told, and Eric, correct me if I'm wrong, he was told by the bad guy, "Oh, you got a gun, I got one too," right? Isn't that what he said?
That claim was made. So Dad immediately calls 911. As soon as Dunning returns to his vehicle, Dad calls 911.
So the bad guy tells me, "I got a gun too,"
and he is
and is trapping my family.
Jared is overheard, and the law considers certain statements to be highly reliable. One of those exceptions to hearsay is a statement made in the moment while seeing the event. And while we never hear Dunning say he has a gun too, Bretherick repeats to his dad, which is then overheard and recorded by the 911 call. Dad, he says he has a gun too.
So someone who is trapping my family, who I'm in desperate fear of, who tells me that they've got a gun. The Army taught me how to deal with those situations. And I would employ the training that I have had, which was protect your own life and those of your loved ones.
I'm gonna say the way I hear it, it's kind of bad guy's lucky that he didn't get shot right then.
Well, if Dad had waited for Mr. Dunning to do what he had done in the past, and we know what Dunning has done in the past. If Dad had just waited till Dunning opened his car door and kept the gun hidden until Dunning opened his car door and then put one in him, it would have been a much easier call, because he then attempted to enter a vehicle that didn't belong.
Right, but it seems like he was trying to avoid avoid confrontation and do what I think a lot of us as concealed carry holders do, which is avoid having to shoot someone.
Yes.
And just basically say, listen, dude, like, get back in your car and drive away. Like, I got a gun, go away. And the guy should have just jumped back in his car and drove away.
Right. And instead he's on a year's probation for doing what any one of us would have done. Maybe not the same way we would have done it, but
all right, I have a question
in his family.
Okay, now, obviously, as I'm understanding it's being told, the way it's being told to me, he pled out because he was scared that he didn't want to roll the dice. That
3 years in jail
come
minimum.
back.
Well, here,
Would come back on him. Now, wait, hold on. My question is this: in this situation, is this like everybody in the jury has to come back with the same verdict, or?
Yes.
Okay, so what is the likelihood of 12 people not seeing common sense?
On the self-defense immunity, he had already lost that.
well, hold
There's
on.
no jury.
What? How do you go to court or be charged with a crime without there being a jury of your peers?
On self-defense immunity, there is no jury. It is the judge, and only the judge.
Okay, so if the judge would have said, I see this going to a crime, he'd still end up in front of a jury, though, right?
For the follow-on criminal trial, yes, but to decide whether or not he was immune from prosecution, it's just the judge. And so this is what we're trying to change, is when you're faced with that judge at the pretrial hearing, who has the burden of proof? Because the judge even said, this is a close call. And if the burden of proof was the other way around, I'd be ruling for you. Or something to that effect, right?
Okay, and that's SB 128, right?
Yes.
Okay. Well, what the other one we were looking at, that was SB 140, right? For open carry, right?
Right.
Okay. Did we get to that one yet, or are we still on the other one?
Yeah, we discussed that one a minute ago. That's the one that will allow open carry, and there's some additional provisions. It'll allow open carry with a license.
Okay.
The bill is also crafted to allow for campus carry, and carry in the legislature.
Yeah, where have you been, Night Strike? Jesus.
Well, I'm trying to make sure that we're keeping up, because I
want to answer Heavy B's question, because this is important.
Oh, okay.
He's asking the question about, well, you got a jury, and in Florida, your jury's only 6 people, by the way, unless it's a case. But this is an important question. Is the idea is, well, why would you plead guilty or plead no contest if you weren't? All right, he was facing. And I will tell you, after I did the appeal, a guy named Mark O'Mara, who y'all may have heard of, he represented a guy named Zimmerman. He took the case over at that point. If Mr. Bretherick had gone to a jury and been convicted, the judge would have had no choice but to adjudicate him guilty of a felony. So assuming the jury said guilty, he would have had no choice but to adjudicate him guilty of a felony. That would have been a felony conviction. He would have had to have sentenced him to a minimum mandatory 3 years in prison. It could have been up to 5. And he would have lost his civil rights forever. The deal he took was a 1-year probation, so no time in jail. And at the end of it, he still has all his civil rights when it's over.
1 year probation, and it all goes away.
And he's probably a good guy, so he probably won't, break the probation.
This guy is an all-American, freaking corn-fed, just I mean, he really is a poster boy.
And the whole family is. The whole family are just good people.
I mean, we've got two combat. We've got Vietnam vet disabled parents. We've got his young daughter, and him trying to defend them all. The fact that he wound up on a year's probation is just a travesty of justice.
Yeah, I totally concur, and that's why I'm wondering. It's like when I feel when Eric told me that
happening in California, but I don't expect that happening in Florida.
No, actually, in California, for one, we have 12 jurors in California, so it's harder to get 12 people to see the same way as it would be with 6. I didn't realize there was only 6 in Florida, so that actually exponentially decreases your odds of success. So I can see why he took the plea at this point. It's my opinion. I think it's BS that he had to, but as Sean stated. But thank you for answering my question, Eric. I appreciate it.
Sure.
Okay, so are we done with all the laws or the bills that have been, filed?
That's pretty much what we've got so far. It's very in the process. We're going to have a lot more bills filed. There's a couple I'm aware of that I will talk about on subsequent episodes here, but they're not filed yet, and we're looking forward to them.
All right. Are there any events or things coming up with Florida Carry that we should be aware of or we should look out for?
Right now, we're looking at this summer having a members meeting that we're going to have. We're looking at Central Florida. We're still ironing out details, but Florida Carry will have a member meeting to which our members and our prospective members, anyone who might be interested in joining Florida Carry, will be invited, and we'll be putting out details on that here in the coming months. Right now, it's just getting into the legislative session and fighting the bad bills and trying to pass the good ones.
All right, I wanted to ask you about something because I saw I linked it earlier in the chat before we started. We went live about Richard. Saying he's not too optimistic about what's going on with the whole Florida government right now, so he doesn't think that anything's going to really happen with open carry. Can you comment on that?
Yeah, well, we have an anti-gun chairman of the Senate Judiciary Committee. That is concerning. We have a pro-gun chairman of the
Flip-flop that.
criminal justice.
Yeah.
Sorry. We have an anti-gun Democrat who's in charge of the Senate Criminal Justice Committee. We have a pro-gun legislator who is in charge of the Senate Judiciary Committee. Bill assignments are going to matter. Our Senate leader has said, our Senate president has said that, bills are going to go to the committees that have jurisdiction over those bills. We're going to be looking closely at what bills get assigned to what committees. There's a lot of concern over the Criminal Justice Committee and what's going to be passed out of there. And there's some concern over even the Judiciary Committee, even though we have a very pro-gun chairman. We have some Republicans on that committee who really haven't proved themselves as being pro-Second Amendment Republicans. And it's a hard road to hoe, and we're going to have to work a lot. to get any of these bills passed.
All right. Being a little further north, I'm going to center this in a bit. Being a little further north from you guys in South Carolina, we've had a long-standing problem where while most of the state is Republican, the issue is we've still got areas sparsely that are heavy liberal, and that ends up with our state Senate having a lot of Democrats in it, and then half of it is Republicans as well. So honestly, if you guys don't get open carry in Florida, the likelihood of South Carolina ever getting open carry is out the window.
Wait, South Carolina doesn't have open carry either?
No,
they're one of the 5 states.
I have to literally the way around that is, in South Carolina they say, well, you don't need it because you can just carry your gun everywhere in your glove box.
Eric, would you like to expound upon the reason that Florida and South Carolina do not have open carry?
Yes, but if you want the shorthand version, you can go watch a video produced by Jews for the Preservation of Firearms Ownership, JPFO, called No Guns for Negroes. That is why South Carolina and Florida have the restrictions they have on carry.
Yet they took the flag down, and that's all I'm going to say on that. They say no for the white people to have guns too, open carry firearms, but they still take the flag down.
All right. So here's what has happened. There were laws that were originally only applied against the African American, and then they said that, well, no, we have to apply a law that's equally. So since we don't want African Americans to have guns, we're just going to prohibit those rednecks too. So unless you have the money to pay for this license and can get your city, your county council to say that you're a person of good moral fiber, you can't have one.
So then all of the people that are in the in crowd, they can get one no problem, and then they can still keep the people they don't like from having them.
Right. Then later that morphed into shall issue, because they started saying, well, these counties have too much discretion in saying who has good moral fiber and who doesn't.
Oh yeah.
So now
we're going to have a gun board.
We're going to say that everyone who's qualified can get one if they have enough money to pay for it.
Yeah, here's the clincher here in South Carolina, though. Yeah, you can't carry it openly with at all. You can carry with a permit concealed, but you can buy whatever the hell you want and keep it at home no matter what.
Well, and even keeping the cars, that's kind of a good step in the right direction, because in Michigan, if it's in the car, it's considered concealed. So you have to have a permit.
In Florida, we have a law that says that if it's in your glove box or any kind of closed container, you can have it without a license. So if you have it in your center console, if you have it in your glove box, you don't have to have a license. You can have a gun.
Yeah, not here. You have to have your permit for
and
coming
actually,
in the car.
The first case where that was challenged was actually a black man who was driving a car and had a gun in his glove box, and they actually said that, okay, you can have that, and then the law was changed to say that he couldn't, and then the courts bit back again, because there was a time where the courts were actually protecting the right to bear arms. Unfortunately, right now, there are only a few courts actually protecting the right to bear arms. And it is a scary time if you believe in that right.
And so there's something that I kind of want to mention. It's a little shameless plug and then a little putting you guys on the spot. Will you keep us updated on these bills as they go through over on Every Second Matters? Because I think everyone should go use Every Second Matters because it's an awesome idea, and I'd like to see more people using it.
Oh, absolutely. We'll have a representative there every second. It'll either be me or Steve Moretti, sometimes both. Last Sunday, I think, or last second, I think it was both of us that showed up. I kind of showed up toward the end of the day.
He needs the website.
Yeah, where you could post up just like a link or a little update or something. It basically for the
absolutely. Get with me after this and give me a little tutorial on how.
All right, sure thing. And for the people listening, a very elevator speech. It's basically a place where any of the gun rights organizations kind of have their own page or their own channel, like a Facebook kind of thing. And then they can post up updates on this is what we're doing. Maybe they have a meetup. Maybe they need some help. They're saying, hey, we're doing raffle tickets. We need to raise money or, whatever. And so the people in the 2A community can go there and kind of get a very quick look at what's going on in all the different states and on the federal level. So everyone should check it out. And I'm done.
All right. Well, are we done? Do we want to talk about anything else or?
Yeah, 9 or 45. You want to talk for another 5 hours?
I don't. Well, we are only supposed to do this for about an hour. Sometimes we go over.
Hey, if we have a good one, dude, you got to ride that horse when it's running strong.
Right, absolutely. But we have Sean here. We have Eric here. So we've had a really good chat. I almost don't want to kill it. So I'm asking you guys, do we have anything else we need to talk about?
No, I don't really. 45 is the answer to Smeggy's question.
You are incorrect. It is 9.
I'm
No,
going
it is
45
because it's closer to 42. You should listen to me. I know what I'm talking about.
Can we just split the difference and go 10 millimeter? Just be done with it.
See, I believe that shot
40,
placement
10,
is what's most important. Therefore, you should carry a 45 because we carry fewer rounds, but we place them exactly where they need to be, and they're devastating.
in the head.
Yeah, but I carry more rounds, and I still place them where they need to be, and I have more of them there.
See, if you're carrying more rounds, that means to me that you're not a good shot.
So it just means I want to put multiple things in the same place. And without any recoil, I just put them all in the same hole. I just cloverleaf my paper targets all the time.
So you're saying you're recoil sensitive. I'm sorry with your girly little arms.
Yes, dude, do you see my picture?
No, his girly wrists.
Yeah, he does literally have sticks for arms. So
actually, they're zip ties. To be honest,
There is.
I'm gonna be truthful.
That's even worse. At least sticks have a little meat on them.
All right. Well, if anybody has any questions for us, email me at nightstrike1@gmail.com. We'll answer your questions. If you have topics or suggestions for the show, please go ahead and send us an email anyways and let us know what you think. We're always looking for input. Please, constructive criticism only. I don't want to get spammed or I don't want.
Are you saying you're thin-skinned? You don't want to get made fun of?
I can handle the fun.
People who.
I'm sorry. 15 rounds of 45. I'm not compromising on capacity.
Oh, okay. I'll give you that one. I'll give 15 rounds of 45 is better than 17 of 9. I will give you that.
All right. I said 45 anyway, so either way, you've already got me sold. But yeah, if you've got any ideas, constructive criticism, be nice. I'm trying to be nice here. Other than that, guys, do you have anything you want to plug before we go ahead and kill it? Or
absolutely,
go
to floridacarry.org. We need your membership. Go to floridacarry.org. I cannot tell you how important right now with what we're doing here in Florida and how, look, Florida gun law translates to all the states. If you have stand your ground, it came from us. If you have concealed carry, it came from us.
You guys are kind of like the counterbalance to California.
Yeah,
All the bad gun laws get passed in California and spread. All the good gun laws get passed in Florida and spread, and they meet in the middle.
well, hey, listen,
preemption came from us.
when we have our next census, New York is losing a representative and Florida is gaining one.
Wow, that's bad.
What?
We have a number of members who are not Florida residents, but a lot of them have Florida concealed carry licenses. A lot of them vacation here. We need your membership. We need your support. I have to pay this lawyer. He has to go lobby in the legislature for us. He has to go fight cases on our behalf. And I have to run this organization. We need your time. We need your volunteerism, and we need your money. So this is an absolute plea to join Florida Carry.
So, Sean, does that mean that one of these days we may have to do, a live Google Hangouts telethon?
I might have to get Sally Struthers to come talk. Feed the right to bear arms.
Feed the hungry guns.
Yeah,
Feed Florida
for
3 cents a day.
For just $1 a day, you can support the right to bear arms.
For $2 a day, you can support a 45. For just $1.09.
For just $1.25 a day,
Guys,
you
y'all
can be a life member of Florida Carry.
Show that Caltech PMR 30 that somebody cares.
All right, Eric, what did you want to say?
I wanted to say good night.
That's probably the
seeing
right
you again,
response. This is the most straight show we've ever done. Okay,
Yeah,
so
it
the
really
silliness
is.
is coming out now.
So thank you, Eric, for jumping in and being Sean's wingman.
Well, Sean tries to get me in whenever he can. I've got 2 little girls that demand quite a bit of time, but I do love doing these, and I would love to come back sometime because I'm on with G-Webs a good bit, and I have a ball doing these things.
Yeah, you're always welcome.
Thanks, guys.
Yeah, you're always welcome. All right, we'll finish this up. Heavy B, are you on this weekend?
Yes, this is the alternate Friday. This will be Friday Night Sights Friday on the Heavy B channel.
All right, Travis, check out you on YouTube, right? What is it, Travis
P11. Yep.
There we go. Travis
And
P11.
I think I'm gonna be doing if I get to 500 subs, I'm gonna do another giveaway. I gave away a spotting scope when I hit 400, and we're about to 500, so I'm excited. Good stuff.
Right
All
on.
right.
Congratulations,
Yeah.
brother.
Yeah,
Speaking
man.
of giveaways, we're
Love
going to
it.
talk about that in just a second. So,
Cool.
Jimmy James, what do we need to watch out for every morning?
The early watch, and it's on every single day, Monday through Friday, and we are working something out for Saturday and Sunday. But Saturday evenings we are on, and come on down to gunchannels.com. It's a great place.
All right. We already went in Florida Carry. Nathan's not there right now, so I'm going to plug sheepdogleather.com. Go there if you need a really good gun belt to hold your holster in. Keep your holster in your pants up. If you need a good holster, whether it be for open carry or concealed carry, go right there. He also does magazine pouches too, so you can get the whole setup. Sheepdogleather.com.
Yep, and that's what I was going to say. I got the whole setup from him. I got a belt, mag pouch, and outside the waistband holster. And I really like it. And he put the Every Second Matters on the outside of the holster. So I'm just going to queue myself up and replug Every Second Matters.
All right, so
Outstanding. And let's not forget the AK-47 buyer's guide for all your AK-47 wants and needs.
taking over my show for me. Thank you. All right.
Well, somebody has to.
So last but not least, I mentioned in an earlier video, just a small video, that we're going to do a AR-15 carbine length quad rail giveaway. So I've talked it over with Smegs, and what we're going to do is, if you want to win that AR-15 quad rail, you need to email us telling us in the subject line and the actual message that you want to enter into the giveaway. Just email this email address right on the screen. If you're a Gun Channels member, you'll get 2 entries. And at the end, whenever I decide to go and pick the name out of the hat, so to speak, I will do so probably live on air. Okay?
And so in your email, just say what your Gun Channels member name is. So you get 1 entry for email and then 1 for having the username in there.
1 for being a Gun Channels member, because we don't want to exclude Gun Channels, but at the same time, we don't want to exclude YouTube either. So everybody gets a shot. If you're a Gun Channels member, you're a little more special, but not too much. You're all special.
Let's face it, you viewers are like our children, and we like the Gun Channels members more. Sorry, we like your brothers and sisters more.
Anyways, thank you all for listening. Thank you, Sean, and thank you everyone else who's been on my panel for being here. That's all we have to say. So this was Hit or Miss.